Peace, everyone. Welcome. Welcome to Moorish Monday with Abdullah Tale Mosi Bey. Got my special guest here. You've seen his brother many times with me. All right.
Peace.
The topic, applying legal principles to draft pleadings and motions. Special guest, Brother Israel Bey. All right.
Peace.
Say something, brother.
Peace. Can you hear me?
Yeah, you sound low. It might be on my end, though.
Peace. Okay, what about now?
You still, but it might be on my end. Wow. But how do I sound?
You're good. You clear to me.
Yeah, but you really low. I got my volume all the way up. So it might be on my end. So just take you have the floor.
All right. So peace. Yeah. Today's lesson is applying legal principles.
You know what, Israel? You were experiencing this on Saturday. Try to.
No, I couldn't hear y'all on Saturday.
What's that?
I couldn't hear y'all on Saturday.
All right, I got you.
You can't hear me, so I don't. And it was a different Zoom. This one, audio. Yeah, it's not.
I can't hear you at all. Wow.
What about now?
You're very low, man. I won't be able to.
What about now?
No, low.
Check.
I might have to do something on my end.
Man.
Let me see.
Can't hear him.
I could.
No, come back on his.
Brother Hank, are you there?
She may be hear him too. There too, right?
Once again, we have Brother Israel Bey applying legal principles to draft pleadings and motions. Can you have somebody type in the chat? Can you hear Brother Israel? Have them type in the chat. Can we have somebody type in the chat? Israel.
Check.
Have them type in the chat. Can we have somebody type in the chat? Israel.
Check. Yeah, I can hear it. It's clear on the video, brother.
Yes, I can hear it. Yeah.
Gotta go check it on. All right, so today, get to it. Today's topic is applying legal principles to draft pleadings and motions. Right, we're gonna use these legal principles: rule of law, due process, source of law, application of law, operation of law, finding of facts, conclusion of law, transparency. Right. Disclaimer: this information is for general guidance only and should not be taken as legal advice. Consult with a qualified attorney for advice specific to your situation. So, principles of law / legal principles. Rule of law. Government's sole obligation is to the Constitution. Due process. The balance between substantive rights and procedures. Source of law. Authorizes and supports legal actions. Application of law. Laws and or statutes are applied to the facts of the case. Operation of law. Law should function without mistakes, errors, defects, and omissions. Findings of fact / conclusions of fact. Specific actions in a case / situation are found in the complaint. You'll always find the facts, the actions in the complaint. Conclusion of law, made by matching the elements of the actions with elements of the law or statute And transparency. All parties have the right to be informed of how the legal system is operating. All right. So principles of law are fundamental concepts that form the legal system and guide the creation, interpretation, and application of laws. They can be categorized into several main groups. Principles of constitutional law relate to the fundamental rules and structures of the government. Separation of powers divides government responsibilities into distinct branches to prevent abuse of power. Checks and balances ensures that no single branch of government becomes too powerful. Rule of law. All actions of government are bound by law. Right? All actions of government are bound by law. So back up here. Source of law. Authorizes and supports legal actions. All actions of the rule of law. All actions of government are bound by law. We want to get more into the rule of law. So governments need to have good laws, institutions, and processes in place to ensure accountability, stability, equality, and access to justice for all. This ultimately leads to respect for human rights. This ultimately leads to respect for human rights and the environment. It also helps lower levels of corruption and instances of violent conflict. This concept is called rule of law. It affects everything about where people work and how they live. By having a strong rule of law, governments give business and society the stability of knowing that all rights are respected and protected. A strong rule of law includes clearly written and easily accessible laws that create certainty and enforceability of legal rights, an independent and impartial judiciary that promotes fairness and ensures transparent, timely, and predictable resolution of disputes. Predictable resolutions. Effective and efficient public institutions that empower business and individuals to make a positive contribution to the economy and society. There are great benefits to business and other stakeholders in respecting and supporting the rule of law. Where the rule of law is weak, it is harder for responsible businesses to function and to meet their legal obligations and have their legal rights protected. Companies need governments to offer a strong rule of law so that businesses can meet their commitments to universal sustainability standards, including the UN Global Compact's 10 principles. So what is the role of the judge? The role of the judge as a referee, the judge cannot present a claim on any party's behalf. The judge cannot argue a legal defense. The only role of the judge is to uphold the following: the Constitution, the legal procedures, and the rules of the court via code of judicial conduct. The judge must be impartial and fair to both sides, upholding the rule of law. The judge must be impartial and fair to both sides, upholding the rule of law. The rule of law is no one is above the law. The Constitution sets the rule of law. Right? So from the rule of law, we have due process. Constitutional due process. Remember the obligation, government's obligation, Constitution. All right. Constitutional due process is for all governments. Constitutional due process refers to a legal principle enshrined in the 5th and 14th Amendments of the U.S. Constitution, guaranteeing that the government cannot deprive a person of life, liberty, or property without due process of law, meaning it must follow established legal procedures and provide fair treatment before taking any action against an individual, essentially ensuring fundamental fairness in legal proceedings. Fifth Amendment, no person shall be deprived of life, liberty, or property without due process of law. 14th Amendment, no state shall deprive any person of life, liberty, or property without due process of law. Procedure, key points: procedural due process, procedural due process. This aspect focuses on the specific steps the government must take before depriving someone of a protected interest, such as providing notice, an opportunity to be heard, and a fair hearing. Substantive due process. This aspect examines whether the government's actions themselves are fundamentally fair, meaning they can't infringe on certain basic rights, even if they follow proper procedures. Application. The Fifth Amendment Due Process Clause applies to the federal government, not the state governments, but the federal governments, while the 14th Amendment Due Process Clause extends the same protections to state governments, not the federal, but state governments. So if anyone was wondering why the Due Process Clause is in the Constitution a couple of times, the Fifth Amendment applies to the federal government, 14th Amendment applies to the state government. So the 14th Amendment was created to provide due process to the subjects or to the property, the people who were classified as United States property or subjects before the 14th Amendment. So the 14th Amendment did not make us U.S. citizens. The 14th Amendment did not make us subject to the United States. We were already subject to the United States. We were subject to the United States via the territorial sovereignty that was transferred by previous colonial powers, which we were previously subjected to. And when they transferred that territorial sovereignty via cession treaties, that Spain, France, England / Great Britain, when they transferred their territorial sovereignty to the United States, the property, the people that were subject to those previous colonies or colonial powers, they were transferred to the United States as well, depending on the clause of the treaty. So, like with Spain, with Mexico, the Treaty of Guadalupe, I want to say Section 8, it allowed the Mexican citizens to choose to either remain where they stayed, like California, California, Colorado, Arizona. They could choose to stay there and become U.S. citizens, or they could pack up their property, pack up their belongings, and move to the new borders of Mexico, of the Mexican government. So with France, there was a clause in the treaty of that's called the Louisiana Purchase Treaty of 1803, and that's between France and the United States. France ceded territorial sovereignty to the United States. I want to say Article 1 and Article 3, the French subjects were transferred to the United States. So we were Spain, France, they had already stripped us. They had already stripped us Moors of our nationality. So we were denationalized before the United States was established. All right. So when all that happened, when that territorial sovereignty was transferred to the United States, and then they created the 14th Amendment, all persons born or naturalized in the United States and subject thereto or thereof are citizens of the United States. So our ancestors were the original subjects of the United States, right? Moors were denationalized subjects of the United States. And then, so, that's why it says in subject thereof. Once they had children, those children were now born in the United States, meaning the United States jurisdiction, occupying, exercising territorial sovereignty. All right. So the 14th Amendment did not make us Moors, denationalized Moors, labeled and branded as Negro, blacks, and colors. It did not make us subject to the United States. So that birth certificate, none of those things made us subject to the United States. There was no agreement. There was no documentation that we signed to agree to become subjected to the United States. All right. So just wanted to clear that up. All right. So now we have substantive principles. Substantive principles define the rights and duties of individuals and entities. So we have substantive principles: equality before the law. Everyone is subject to the same laws and has equal protection under the law. Fairness and justice. Law should be fair and just, ensuring equitable treatment for all. Freedom and liberty. Individuals have the right to freedom and liberty within the confines of the law. Substantive due process, a legal principle, essentially meaning that the government cannot deprive a person of life, liberty, or property without a sufficient, compelling reason, meaning the law itself must be fair and not infringe on fundamental rights, considered deeply rooted in American history and tradition. Key elements include identifying fundamental rights, those are the substantive rights, demonstrating a substantial government, demonstrating a substantial government interest to infringe on that right, and applying the appropriate level of judicial scrutiny. So once again, fundamental rights, substantive rights are the same as fundamental rights. Fundamental rights, substantive rights, personal rights, those will all be synonymous. So how does substantive due process function? Substantive due process looks at the specific wording in the Constitution and statutes to see if it infringes on fundamental rights. So if the procedures, if the government follows the procedure to the T, right, but somewhere in there violates someone's substantive rights or fundamental rights or personal rights, then that's an error. Because government is there to protect one's fundamental rights, one's personal rights, one's substantive rights. So if government was to infringe on those rights without having a compelling interest, that would create a conflict of interest. They're going against their sole obligation, right? The sole obligation is to the Constitution, and the Constitution was drafted to provide protection, all right, to the people, provide protection to the people for their rights or whatnot, to the people's rights. All right, so substantive due process, identification of fundamental rights, right to equality. These are fundamental rights, some of the fundamental rights, substantive rights, personal rights. Right to equality. This principle prohibits discrimination based on factors like race, religion, caste, sex, or place of birth. This principle is embodied within the 5th and 14th Amendment of the U.S. Constitution. Freedom of speech and expression. This principle is the right to express ideas and opinions without government interference, retaliation, or punishment, even if the expression is considered offensive, hateful, or immoral. However, such expression must not violate rights of others, falsely defame someone. This principle is embodied within the First Amendment of the U.S. Constitution. So principles, we're looking at the principles. Right to life and personal liberty. This principle refers to the right to live without arbitrary interference and the freedom to make personal choices and live one's life without undue restrictions. Essentially, both the right to not be killed and the right to personal autonomy within the law, often considered together as a core principle of human rights. Freedom of religion. This principle is the right to practice one's religion without government interference, as long as it does not violate public morals or a compelling government interest. This principle is embodied within the First Amendment of the U.S. Constitution. Right against exploitation. This principle protects individuals from being forced to work against their will, guaranteeing that no one can be compelled to work under exploitative conditions or be subjected to degrading treatment for labor purposes. It aims to safeguard human dignity and freedom from coercion and abuse in the workplace. Right to constitutional remedies. This principle protects and enforces the fundamental rights of citizens. It allows citizens to seek relief from the judiciary if the state or another entity violates their constitutional rights or the rights protected by the Constitution. So what is the role of the defendant? Role of the defendant in the status of pro se, or any status really. The defendant is responsible for knowing her/his rights and the role of each party, prosecutor, the judge, and the defendant. The defendant, once upon knowing her/his rights, can protect and preserve the rights she/he has. The defendant is responsible for making her/his legal defense by knowing the following: knowing when to strike statements from the record, knowing when to suppress evidence, knowing when to object, resulting in a plain error for appeal, making sure the court is preserving the record for appeal purposes by filing proper motion pleading, and by knowing the principles of law. All right. Procedural principles. Procedural principles govern the processes and methods by which laws are enforced and legal matters are adjudicated. Due process. Legal proceedings must be fair and follow established rules and procedures. Right to a fair trial. Individuals are entitled to a fair and public hearing by an impartial tribunal. Presumption of innocence. An individual is considered innocent until proven guilty. Procedural due process, civil rules of procedure, and administrative rules of procedure. So all these things we need to know before pleading, making a plea, before drafting a motion. You know, these are legal principles / principles of law they help us, they guide us through the legal system. So, you know, it takes away the guesswork, the assumption, the headaches, you know, the anxiety and all. It gives us a tool to measure government, to measure life, really. Know how to look at things. So let's see. So we have two sides. We have civil rules of procedure. We have administrative rules of procedure. So this is the procedural due process. Procedural due process breaks down to civil rules of procedure and administrative rules of procedure. Civil rules of procedure, established and enforced by the courts, refers to the set of rules governing how a civil lawsuit is conducted in the courts, ensuring fairness and order in the process, secures the just, speedy, and inexpensive determination of every action and proceeding. And then we have the administrative rules of procedure established and enforced by government agencies. Government agencies, not government, but government agencies. Government agencies would be like the DMV, child support agencies, what's that? The FBI, you know, established and enforced by government agencies. So the administrative rules of procedures are established and enforced by government agencies. Regulations created by government agencies to implement and clarify existing laws within their jurisdiction, essentially acting as detailed guidelines for how the agency will operate and enforce those laws. Governs how agencies function within their specific area of expertise. So the agencies do not create the laws. They create their rules and guidelines and procedures based on the already established existing laws or statutes. Based on the existing laws or statutes. Civil rules of procedure. Commencing an action, the cause of action. So the cause of action. Before anyone can bring a cause of action, a claim, these things must be in order. These things must exist. The existence of legal duty that the defendant owed to the plaintiff. That's one. The defendant's breach of that duty is two. The plaintiff's sufferance of an injury, that's three. And then four, proof that the defendant's breach caused the injury, typically defined through proximate cause. So just because one had a legal duty, like just because the defendant had a legal duty to the plaintiff and the defendant breached that legal duty to the plaintiff, and yes, the plaintiff may have suffered an injury, but now you have to check, put it together to see if it matches, to see if the defendant's breach of duty actually caused the injury to the plaintiff. So we have to be specific. Everything must fit like a puzzle. Civil rules of procedure, service of process. The service of process. A party in a lawsuit or legal proceeding gives to another party an appropriate notice of the initiation of legal action. What does it involve? Delivering legal documents, usually including a summons and complaint to the defendant. Purpose: to officially notify the defendant of a lawsuit and give them the opportunity to respond. This is due process. Importance: proper service of process is crucial for court to have jurisdiction over a defendant and for the lawsuit to proceed. Who can serve process? A professional process server, a sheriff, or sheriff's deputy, or sometimes a private individual, depending on state laws. Methods of service: personal delivery, certified mail, substituted service, depending on the circumstances and state rules. So pleadings. A pleading is a formal document that states the basic positions of the parties in a lawsuit. This stage is set when the person bringing the suit files a complaint. Jurisdiction. A short statement of the grounds for the court's jurisdiction. These things must be in the pleading. These things must exist in the pleading. Jurisdiction. A short statement of the grounds for the court's jurisdiction. The reasons. So the claim, a short and plain statement of the claim that shows the pleader is entitled to relief. Demand, a demand for the relief sought. which may include different types of relief. Legal sufficiency. The pleading must show sufficient facts in short and plain terms that entitle the plaintiff to relief. Motions. So that one was pleadings. Now this slide is motions. A motion is a formal request made by any party for a desired ruling, order, or judgment. Case caption. So a motion, when drafting a motion, these subjects will be in there. Case caption. Identifying information like the court, parties involved in case, and case numbers. Title. A brief description of the type of motion being filed, e.g., motion for the summary judgment. Introduction. A concise summary of the motion's purpose and key arguments. Facts. Detailed presentation of the relevant facts related to the case, including supporting evidence. Legal arguments. Analysis of applicable laws and legal precedents to support the requested relief. Supporting evidence, affidavits, exhibits, or other documents to substantiate the facts. Opposition to motion, if applicable, arguments presented by the opposing party against the motion. And prayer for relief, a clear statement of the specific outcome the moving party is seeking from the court. Proper way to draft a motion. So you can use this as a checklist. For the pleadings, you can use this as a checklist. For the motions, you can use this slide as a checklist. Substantive due process. When government's actions substantially interfere with fundamental rights. Direct impact on a protected right. The government action must clearly and directly affect the ability to exercise a recognized right, not just create a minor inconvenience. Significant restriction. The interference should be substantial, not just a minor limitation, and should meaningfully impede the exercise of the right. Lack of compelling government interests. The government must demonstrate a strong and necessary reason for the interference, and a less restrictive alternative may not be available. Not narrowly tailored. If the government action is overly broad or impacts more people than necessary to achieve its goal, it can be considered a substantial interference. Interfering on citizens' substantive rights. Substantive due process. Examples: banning all protests on a specific topic in a public space. Restriction on freedom of assembly. So banning all protests on a specific topic in a public space constitutes the restriction on freedom of assembly. Compelling citizens to disclose their religious beliefs on government forms constitutes interference with free exercise of religion. Censorship of news articles critical of the government constitutes the restriction on freedom of press. Prohibiting all political speech on a college campus constitutes the violation of freedom of speech. An arbitrary arrest without due process constitutes violation of procedural due process rights. So we have to know the difference between substantive and procedural. That's how we measure the due process and check for due process violations. Substantive, again, is your personal rights, your fundamental rights, your substantive rights. Procedural due process is the procedure, the process, the order in which government or institutions operate. So administrative rules of procedure, fairness and transparency, fairness, impartiality, applying rules and standards consistently without favoritism, due process, following established procedures, and giving individuals the opportunity to be heard before making decisions. Objectivity, basing decisions on factual evidence and not personal biases. Equity, recognizing and addressing potential disparities to ensure everyone has a fair chance. Transparency. So these are legal principles: fairness, transparency, open communications, clearly explaining decisions, rationale, and criteria used to reach them. Accessible information, making relevant data and details readily available to all stakeholders. Accountability, taking responsibility for actions and providing clear explanations when necessary, and clear guidelines, establishing well-defined rules and procedures that are easy to understand.
Now we're gonna let the audience know that these that fall under the elements of the rule of law. These are some of the elements of the rule of law, which is a primary legal principle. And Israel gave the list at the onset of the presentation of the legal principles. And the rule of law is a primary legal principle, and these are a few of the elements. We're looking at here: applying rules and standards consistently without favoritism. You know, that deals with legal certainty as an element of the rule of law. Israel, let's talk about attorneys often have conversations among themselves or their clients, and they will let their clients know, oh, it's Judge so-and-so. All right. They have discussions all the time, you know. What judge is it today? Oh, man, that judge doesn't play. That's Judge so-and-so.
Mm-hmm.
You hear that that's all day long among attorneys. That's all day long.
Yeah.
Now, what legal principle is that based in? Ooh, man, it depends what judge it is. On whether you will get a fair treatment. Oh, man, that judge is tough. Oh, identify the legal principle. That judge is tough. It depends who the judge is. Like, what legal principle is that?
Yeah. No legal principle that's not a positive legal principle. So that wouldn't be.
Yeah, it's none. It's not. It's in fact, it's a violation of the rule of law.
Exactly. Yeah.
That's a violation. So attorneys are groomed into that. You know, so you have young attorneys that graduate from law school.
Mm-hmm.
They're 21 years old.
Yep.
And they're groomed into that. Oh, it depends what the judge is. How they groomed into that.
Yep. And it gets
So that's a violation of the rule of law. Depends what judge it is, and whether they got rest last night, or that's not
some coffee in the morning.
Yeah, coffee in the morning and woke up on the wrong side of the bed.
Yeah.
That's arbitrariness. That is the rule of law, and one of the elements of the rule of law is no arbitrariness.
Right.
That's arbitrary. So when you hear an attorney say that, check the attorney and ask the attorney to give you the rule of law for that statement. Tie the statement into a legal principle. Identify the legal principle that statement falls under. Depends what judge it is.
The source of law.
Yeah. So there is none.
Right.
Now you see how that is in the fabric. That becomes how a misconception, that one that violates the rule of law becomes a fabric.
Yeah.
So I just wanted to, I know because you and I have talked about that, and I wanted to bring that forward, because it ties into, this section.
Right. Yep. So it's good for us to know, so we can know how to challenge misconceptions. We'll sense it.
And that's a grave misconception.
Yeah, because it gets promoted to their clients. Everybody gets a lawyer. They promote that same misconception to the clients, and that's
Depends on the jury. The jury selection depends on what the jury say, and if the jury likes you or not, then make sure you smile.
Yeah.
And
wear these clothes. Yeah.
Yes. Like what principle does that tie to? So it's a nation of laws and not of men. A nation of laws and not of men. That is tied to the rule of law. So with the way they're presenting it is in a violation of the rule of law. It depends what judge it is. What?
Yeah.
Well, I didn't know this was a nation of men and not of laws.
Yeah.
This is wow. What principle is that? Identify the legal principle, a nation of men and not of laws. Identify what legal principle is that? A nation of men, and because depends what judge it is that's what? Men not of law. There's no legal certainty. Where's the legal certainty? Accountability. Equality before the law. No one's above the law. Like, where's that? That doesn't sit within the rule of law. This is very important, and very important for us, moving forward. And as we, the Moors, are teaching our people, guiding our people back into restoring, and as we on the road to recover our lost Moorish sovereignty, and including on the road to recover our lost Moorish sovereignty, is to teaching these principles so that we can restore and instilling the knowledge of the rule of law, due process, and constitutional self-governance. So in order to talk about self-determination, that self-determination is having the knowledge of self-governance. Like, how would you have self-determination when you don't have the knowledge of these principles, so that we can govern ourselves to ensure the integrity of our political structure as we are on the road to recover our lost Moorish sovereignty, to revert to our pre-existing sovereignty that we lost through the Spanish, French, Dutch, English, Portuguese conquest, colonization, discovery, and subjugation of our land and our people. Am I making very clear? So just wanted to bring this. I want to bring this home. This is major. This is a major concept, because when you have a false concept that sets in for decades, that thousands of attorneys for decades have pushed. So this is not something that we could just say once. We might have to say it 1,000 times. We may have to say it 1,000 times. Like, I'm talking about with emphasis, because remember, decades, thousands of attorneys has pushed that false concept. Abdullah, you don't know what you're talking about. Then I shut my mouth. Once they say I don't know what I'm talking about, I shut my mouth. I give them the floor. All right, so I don't know what I'm talking about. Then once they say that, no problem. Identify the rule of law where that statement is based in. That's it. There's no back and forth. Once I say that, I shut my mouth. They got the floor. I'm not going to get upset when somebody says I don't know what I'm talking about. I'm not. I'm going to challenge them to support their claim that I don't know what I'm talking about. Saying I don't know what I'm talking about means nothing. What is the rule? What is the principle, legal principle, where tie that statement to a principle, a legal principle? They can't. They can't. All right, continue, Israel. Good job, brother.
Transparency, open communications, clearly explaining decisions. I already read this, didn't I? Yeah, I already read this. All right, so yeah, next slide. So principles of law. The principles of civil law apply to disputes between private parties. Compensation. Victims of wrong should be compensated. Restitution. Restoring a party to their original position before the loss. Equity. Applying principles of fairness to legal cases. What is the role of the prosecutor? The role of the prosecutor to seek justice within the bounds of the law, not merely to convict. Prosecutor's execution of perfection of claim. The prosecutor must perfect service of process by serving the defendant properly on her/his person or her/his known address. After perfection of process, the prosecutor must perfect her/his claim by ensuring that all the facts are present in the substantive language of the statute. So matching the substantive language of the statute with the elements of the facts of the action. The prosecutor must adhere to her/his constitutional oath. Then the prosecutor can present her/his case to the court. All right. So yes, fact-finding tools are indeed a principle in law. They are essential in various legal processes, including litigation, arbitration, and regulatory investigations. Here are some key points about the role of fact-finding tools in law. Oh, shoot. Did I put it in? All right, what? Disregard that. So what does conclusion of law mean in a legal document? Want to know how conclusions are made in law? A conclusion of law is a judge's determination regarding the application of law based on the facts as found. It's essentially the legal reasoning that supports the court's decision in a case. What are some examples of conclusion of law? Examples include determinations of whether a defendant violated a particular statute or if an action meets the legal definition of negligence. What is the purpose of a conclusion of law? The purpose is to apply legal principles to the facts of the case to determine the rights and obligations of the parties involved. It's essential for reaching a judicial decision. How is conclusion of law different from finding of fact? Findings of fact involve determining the actual events and evidence presented in the case based on the credibility and the weight of evidence. Conclusions of law are legal interpretations made by applying law to these facts. So again, conclusions of law are legal interpretations made by applying law to these facts, to the facts. Who makes the conclusion of law in cases? Typically, conclusions of law are made by a judge. In bench trials, trials without a jury, the judge decides both the facts and law. In jury trials, the jury finds the facts while the judge determines the law.
Hey, Israel, we have people are used to seeing those judge shows like Judge Judy, Judge Mavis,
Yeah.
Those type of judge shows they see. Now, if when they first bring out the both parties, the defendant and the plaintiff, so the first section will be they're hearing facts.
Yeah.
So facts are presenting. You would have any contracts, or if text messages or emails that were sent. All right.
Evidence.
Even though, remember, you have written and non-written contracts. So they may not be a written contract, but if there are transactions regarding text messages or emails regarding something, somebody make an agreement to do a particular job and so forth, you actually see them bringing where the bailiff go get the text messages or contracts or any, and then they hear testimonies. They'll bring in witnesses, all right, so forth. And then that's the first segment of that particular case. And then the judge will go back and say, I'm going to go back to my chamber. I'm going to take a break. I'm going to go back to my chambers. All right. So the first section, that's called the finding of facts. That first segment called the finding of facts segment. And then the judge goes back to his or her chambers. All right. And then when he comes back, he or she comes back, that's the conclusion of law segment. That's the conclusion of law. So I just want that people have seen these judge shows for the past 20, 25 years. All right. So that you see this, how these things play out. Confining of facts segment, goes back to the chambers, comes back. That's the conclusion of law. All right. So I let people know that they already know this. You already know this.
Right.
You've seen this when you watching these judge shows. You already know this.
Yeah, this is the only way they operate. Yeah, so we need to know this, knowing the legal principles. Yeah. All right. Did I finish that? Yeah. So how does the conclusion of law affect the outcome of a case? The conclusions of law directly determine the judgment in a case. They establish whether the facts, as determined, constitute a legal violation or breach, and what the legal consequences should be. What happens if the conclusion of law is incorrect? If a conclusion of law is incorrect, it can be appealed to a higher court. The appellate court will review the legal conclusions without The appellate court will review the legal conclusions without re-examining the factual determinations, unless there was a gross error or new evidence. How can a conclusion of law be challenged? Conclusions of law can be challenged through the appeals process. The appealing party must demonstrate that the judge made an error in applying or interpreting the law. So we're always looking for mistakes, errors, defects, and omissions. Same thing the judge is looking for. Everyone should be looking for that. Mistakes, errors, defects, and omissions. What is the difference between conclusion of law and findings of fact? As noted, findings of fact are about determining what actually happened based on evidence. Conclusions of law involve applying legal principles to those facts to adjudicate rights and responsibilities. How does the conclusion of law relate to the overall outcome of the case? The conclusion of law is crucial as it ultimately dictates the legal outcome based on the judge's application of law. to the established facts. It defines whether the conduct in question meets the legal criteria for liability or compliance. What are common examples of conclusion of law? Common examples include conclusions on whether a law has been violated, if a contract term has been breached, or if there are legal grounds for divorce or custody arrangements in family law. These conclusions directly lead to the legal remedies or enforcement actions ordered by the court. These elements form the core of the legal reasoning in judicial decisions and are crucial in understanding how legal processes translate factual scenarios into enforceable legal outcomes. So this is an example of a motion that was drafted based using the legal principles. Make sure it's clear. Is everything clear? You see that?
Mm-hmm.
All right,
Oh yes, it's clear. It's big enough. Yes.
all right.
Mhm.
All right. One moment. So I'm going to go to this motion page so we're going to do the checklist, the motions, filing the motion. All right. So in a motion, as we discussed earlier in the presentation, the case caption. So the case caption identifies the information like the court, the parties involved, and the case numbers. So this is the case caption. So in the Commonwealth of Kentucky, Fayette County Family Court. So that's identifying the court, the parties involved. Commonwealth of Kentucky, ex-rel, mother of the children, plaintiff. And then the defendant versus the defendant. We'll have the case number, the name of the judge, and the name of the motion to object. So so you use this checklist, the motion slide for the checklist to draft the motion. Well, you'll see everything is in order. The parties, all the parties involved are mentioned. So the next section is the title. The title is a brief description of the type of motion being filed. E.g., motion for summary judgment. So this is a motion to object. That's the title. Introduction will be this paragraph, is a concise summary of the motion's purpose and key arguments. So it reads, now comes the defendant in error who enters this motion to object pursuant to Kentucky Family Court FCRPP Title 1, Section 5 for the applicability of Kentucky Rules of Civil Procedure KYCR 12.02 Section F in the interest of justice, and serves this motion in a timely manner to ensure the defendant is afforded his fundamental right of due process. The defendant makes this motion for the following reasons. So that was the introduction, a concise summary of the motion's purpose and key arguments. I don't know if I'll be able to. All right. So back to the beginning. Now comes the defendant in error who enters this motion to object pursuant to. So this is pursuant to. This is dealing with the source of law. The source of law authorizes and supports legal actions. So this legal action is being brought based on The legal action, this legal action is a motion to object, and it's being brought pursuant to the source of law, Kentucky Family Court, FCRPP, Title 1, Section 5. That is for the applicability of Kentucky Rules of Civil Procedure, KYCR 12.02F. So you can, wherever you are, whatever state or county, you can look for the rules. What are the rules? What are the court rules that regulate motions to object? But first, you want to look for the Kentucky Family Court rules. Look for the rules for the family, for the state family court, whatever state it is, the family court, or whatever type of court. You know, you will look for those rules. It's all about reading the rules. If you don't know the rules, a fair outcome will never be a possibility. All right. So then we got the facts of the case, factual background. No contract. The defendant in error has no contract with, nor wishes to contract with, the Cabinet of Health and Family Services, CHFS. No establishment of paternity. So the facts are no contract, no establishment of paternity, and objection to genetic tests. No establishment of paternity. So on such and such date, Cabinet for Health and Family Services entered a complaint on behalf of plaintiff dash mother and children pursuant to, so the source of law that they use was KRS chapters 205 and 406, claiming the said defendant to be the father with no establishment of paternity. See affidavit in support of motion to object, lines 17 through 20 in Exhibit A. And is referring to the lines, these lines on the outside, these are the lines, what would you call these, like guideline numbers, the number line. This is the number line for the motions for all documents. It'll make it easier for navigation. Easier for all parties. So then the objection to genetic tests. The defendant does not wish to establish paternity and asserts his religious right, which he exercises sincerely, and therefore objects to any genetic testing respectfully. So those are the facts. That's the factual background. The facts are the detailed presentation of the relevant facts related to the case, including supporting evidence. And you can see the supporting evidence in here. That see affidavit in support of motion to object, lines 17 through 20, and the Exhibit A. So now, legal arguments. Legal arguments are the analysis of applicable laws and legal precedents to support the request of relief. So in the legal argument section, we have freedom of contract, statutory overreach. I think there's another one on the next slide. So freedom of contract, the right to enter into a contract or to not enter into a contract is the defendant's fundamental right protected by Article 1, Section 10 of the United States Constitution and Section 19, Part 1 of the Kentucky Constitution. So all state constitutions must be in sync with the federal Constitution. So whatever the federal Constitution speaks on, 9 times out of 10, you'll be able to find that in the state constitution as well. You just have to look for the principle. The principle in this is the right to contract. So that's a fundamental right. The freedom of contract is a fundamental right. a substantive right, a personal right. And it can't be, the government cannot infringe on that right unless they show a compelling interest. All right.
And let's start to look at the supremacy clause, Article 6 of the United States Constitution. It's a supremacy clause. Now, the 13 original states agreed to that by signing. All right, so it's the 13 delegates representing the 13 original states at the United States Constitutional Convention in 1787, from March 1787 to September 1787. The delegates signed on behalf of their states as they were delegates representing their various states. They took the ratification procedures. The ratification procedures were drafted in August at the convention, and the ratification procedures were agreed upon. So the delegates, the 13 delegates from the 13 original states, took the ratification procedures back to their respective states and held based on the ratification procedures. 12 of the 13 states held ratification conventions in 1788. Rhode Island did not hold a ratification convention in 1788. Rhode Island ratified it in 1791. And so the ratification procedures were the guideline in ratifying the Constitution. They held ratification debates. You know, there were ratification debates in the 13 original states and conventions, 12. Now, the 14 on, the states 14 on who are not the original state. So the non-original states are held to this, in that Article 4, Section 3 of the United States Constitution as the omission clause. The omission clause is in Article 4, Section 3, and Article 4, Section 3 is based in the source of law. The source of law for Article 4, Section 3 of the United States Constitution is the 1787 Northwest Ordinance. So from the 1787 Northwest Ordinance was drafted from there. They drafted the language comes from that Article 4, Section 3 language comes from the Northwest Ordinance of 1787, the admission of new states, and there's procedures upon which Congress, by review, to admit new states. There is a lengthy, comprehensive procedures, and in that, in one of the agreements that to be admitted as a new state is to be held there. Thereby, the states are held to Article 6. So I mentioned two sections. I mentioned the 13 original by signing and ratifying. All right, and then you have the fourth from 14 on. All right, by going through by being obligated. All right, and agreeing to be part. To be admitted in new states, they go through a lengthy process to be admitted as a new state. All right. So a lot of people don't know this. So we're talking political science here, political philosophy. All right. We're talking so that's due process there of the admission of new states. There's a very comprehensive, lengthy process. All right. I just wanted to be detailed with that. Yeah. And I know a lot of people don't know this, Israel.
Yeah, it gives them a background. Yeah.
Yes.
So they can know how it applies. Yeah. All right. So statutory overreach, another legal argument. The Cabinet of Health and Family Services, CHFS, must establish paternity before filing a complaint requesting the court to enter a judgment of paternity, declaring the defendant to be the legal father, and asking for the enforcement of child support payments pursuant to KRS 406.021. Freedom of religion. See KRS 446.350 in Section 5 of the Kentucky Constitution. The defendant's religious right to not partake in genetic testing, that is, extraction of blood, tissue, and/or any other biological fluid, is protected by the First Amendment of the United States Constitution and Section 5 of the Kentucky Constitution. See United States versus Zimmerman. I want to say it's 2007. The case would be 2007. It's dealing with the freedom of religion. And Thomas versus Review Board Employment Securities, 450 U.S. 707, 1981. And then, so that is the back to the checklist. The legal arguments, again, analysis of applicable laws and legal precedents to support the requested relief. The applicable laws, as you can see, KRS 446.350 in Section 5 of the Kentucky Constitution. The First Amendment of the United States, this is a mistake right here. This should be the First Amendment, not Second Amendment. First Amendment is the religious rights, freedom of religion clause. Relief sought. Wherefore, the relief, prayer for, or also called prayer for relief, is a clear statement of the specific outcome the moving party is seeking from the court. So relief sought. Wherefore, the defendant respectfully requests this court to enter a judgment of non-paternity and dismiss this case on the grounds of failure to state a claim upon which relief can be granted. Because there was no evidence, no supporting evidence to the claim. There were no grounds. There was no grounds for the claim upon which relief could be granted. So there was a failure to state a claim upon which relief could be granted. And then you have your conclusion. In conclusion, the defendant respectfully asserts the right to due process, which is guaranteed. It's guaranteed by the 14th and First Amendment of the United States Constitution and Section 11 of the Kentucky Constitution. This will ensure a fair and just outcome for all parties involved. Respectfully submitted, signature, address, email address, certificate of service. I hereby certify that a true and correct copy of the foregoing motion to object has been furnished via hand delivery, if you're going to deliver it by hand, or via USPS, United States Postal Service, name, address, phone number, email address. So back to the, let's see, up here referred, it made reference, it says, see affidavit in support of motion to object, lines 17 through 20 and Exhibit A. So this is that affidavit in support of motion to object. And as you can see, the caption, the case caption, the title. So this is an affidavit in support of motion to object. And an affidavit functions as a sworn a sworn statement. What is it? A sworn statement one's free will sworn statement. So it's a sworn statement made by one's free will, not under threat, duress, coercion, or anything like that. Not compelled to make one. So that's the testimony under penalty of perjury. So an affidavit, one making an affidavit, drafting an affidavit, signing it, getting it notarized. That right there, when the affiant does that, that brings liability to them for their words, so they can be held to their words. So I, name, being first duly sworn, depose and state as follows: I am over 18 years of age and am of sound mind and body. I have read and understand the Kentucky Family Court rules. You must read the rules, the court rules. And I'm following these procedures properly. I made a motion to object pursuant to FCRPP Title 1, Section 5 for the applicability of KYCR 12.02, Section F, supported by this affidavit, along with these relevant exhibits. I object to the civil complaint filed by CHFS on the grounds of no contract, no establishment of paternity, objection to genetic tests for sincere religious reasons. 5, I have filed a motion to object in a timely manner. I acknowledge and adhere to the United States Constitution and specifically invoke my right to due process guaranteed to me by this court under the 14th and First Amendments of the United States Constitution. Furthermore, the affiant says not, signature, address, email address. I affirm under penalties of perjury that the foregoing is true and correct to the best of my knowledge and belief. Sign. I don't have the notary statement on here, but yeah, the notary would be on the next page. If I had more access, I was going to go to the actual rules to show how to navigate those rules. But you start at 1. You go to the rules, state whatever type of court rules, and you start with 1. You start with 1. You go in order. That's due process. That's the procedural due process. You don't want to violate your own due process by going out of order. But yeah, using legal principles to draft these motions, pleadings. Let's see. Yeah, so you would look for Kentucky court rule, like I said, the county court rules, because each county may have different rules. The rules could be different. So yeah, that's the end of these slides. Any questions? Do we have any questions about anything?
Type your questions in. Excellent job, brother.
Appreciate it, bro.
Excellent job. It's 8:30. All right. Let's go. Yeah, that's pay. Yeah, here. So we have here applying legal principles to draft pleadings and motions. These are rules of law. The legal principles. We have rule of law, due process, source of law, application of law, operation of law, finding of facts, conclusion of law. Now, and the transparency is an element of the rule. Is one of the elements of the rule of law. And we mentioned we addressed that, and I mentioned about attorneys, making these comments for decades about, depends on what judge you get and whether you're going to get a fair shot. And this judge is mean, and this judge is more lenient, and you hear that all that's every day, all day long.
Yep.
Fairness.
Yeah. So transparency is an element of the rule of law, one of the elements of the rule of law. And the rule of law is the primary legal principle.
like to tell you the truth about our business.
Yeah.
Because that's where they operate down.
Any type your questions in? Go to the chat here. I don't see any questions right now.
Yeah, I experienced that myself. I was an attorney that I was gonna get because I worked with his girlfriend. So he basically
So yeah, part in that. So principles of law for clarity. We're gonna go over this one more time. The rule of law. The rule of law's government sole obligation. Government sole obligation is to the Constitution. That's the rule of law. Government is obligated. The Constitution is established to protect those rights, those fundamental rights, those personal rights, those substantive rights of the citizens. Due process, the balance between substantive rights and procedures. So the procedures cannot violate one's substantive rights. All right. So just because government follows procedure, that does not justify the actions to violate someone's substantive rights unless there is a governmental, unless there's a compelling government interest, a crime involved or something, where one violated another's fundamental, personal, or substantive rights. Source of law authorizes and supports legal actions. So you're moving pursuant to, filing this document pursuant to application of law, laws and or statutes are applied to the facts of the case. If there are no facts, then no law can be applied. So you cannot apply law to a situation that never occurred, that never happened. So there has to be facts. The facts are the acts or the actions that took place. And then the law is applied to that. Operation of law. Law should function without mistakes, errors, defects, and omissions. Everyone should be looking for mistakes, errors, defects, and omissions when it comes to legal matters or contracts and things, such, contracts as well. Because if they find any mistakes, errors, defects, or omissions, 9 times out of 10, those are due process violations. With those violations, you will be considered injured. That would be an injury, and you can be compensated for your injury. Findings of fact and / conclusions of fact, specific actions in a case / situation are found in the complaint. So you read the complaint, and you'll find the acts, the actions, the acts that took place, and based on what's in that complaint will determine how the law is applied, or how the judge will make a conclusion of the law, which the conclusion of the law is made by matching elements of the actions with the elements of the law or statute. So the specific wording, the substantive wording or the substantive language in the statutes have to match up with the elements of the actions, the specific action, the specific acts. And then transparency, all parties have the right to be informed and of how the legal system is operating, meaning you're able to see it. It's like, it would be like a car, a transparent car or something. The hood of the car would be transparent. You can see how everything is operating. So yeah, so that'll be it for tonight's presentation. Applying legal principles to draft pleadings and motions. Once again, disclaimer, this information is not for general guidance. Disclaimer, this information is for general guidance only and should not be taken as legal advice. Consult with a qualified attorney for advice specific to your situation. All right. So catch us again the next Moorish Monday. Or actually, where's our next? Let me check. We have the Moorish Midwest Educational Network every second and every first and third Wednesday of the month. Every first and third Wednesday of every month. So the next session will be June 4th, Wednesday, June 4th. And that'll be on the Moroccan Post Media YouTube channel. So yeah. Thank everyone for tuning in tonight. And Hank, appreciate you for letting us use the platform. Brother Abdullah dropped off, but I wouldn't be able to do this well for Abdullah and the brother King El Bay for showing me the way, the road legal principles, principles of law, correct concepts. So yeah. All right, thank everyone. Peace.